Thank you, sir, for enlightening us with such an important case. Now, I request Akanksha ma'am. Uh, yes, today ma'am is going to discuss about the practice and the procedure of IPR. Also, I have to mention, we have a question and answers round open. So, if you have any questions, you can post it. So, at 10:45, we can discuss all the questions and answers. So, I request
Okay.
Akanksha ma'am to take over. Thank
Yes,
you.
thank you so much, ma'am, providing this opportunity to share my insights in IPR. So, a very good morning to all of you. Let me switch off the camera. I would be more comfortable. Okay. So, in this discussion, I will share the overview. I will share more about the practical and applications over the IPR rather than going much theoretical. So all of us know that what is IPR, as we have already been taught in the college that patent, copyright, inventions, these are IPR. So basically, IPR refers to the legal protection granted to the creators for their inventions, designs, and artistic work. So our Indian IPR primarily deals with the patent, copyright, trademark, and trade secrets. So what are its current practical applications? So we all of us know that now we are entering in our technological era. So everything is changing right now. So the scope of IPR is being now expanding. So how as a lawyers we can glorify our career in this field, I can explain. So our IPR primarily deals with the patent, which is for the inventions, trademark, which is for the brands, and copyrights, which gives the safeguard to the artistic expression. So how our government of India has uh, divided, how it will work. So government of India has divided in 5 reasons for handling of IPR in India. There are 5 regions are Mumbai, Delhi, Chennai, Kolkata, and Ahmedabad. Suppose in Mumbai, how it will work, it handles the region, western region, including Maharashtra, Gujarat, and Goa. And now if suppose if any case come to in Delhi, so the Delhi region would be Delhi, Haryana, Punjab, Himachal Pradesh, Jammu, Kashmir, and Uttarakhand, right? So government has also provided the certain websites. So I would provide a certain websites. I will speak right now. Later, I could share it as well. The Controller General of Patents, Designs and Trademark, IPR India, WIPO, National Institute of Intellectual Property Management, Copyright India, Trademark Registry, Patent Information System. So these are websites where we can work by online only. So I would suggest that it is a very good opportunity for us, that this is the platform where we can do the whole work, like from the beginning to end we can file online, and I would suggest you people go by online because it saves our time and clients money as well. So now let me discuss about who can file trademark in India. Is it attorney or is it individual? Let me clear here. Three people can file. As attorney we can file trademark. Individual can also file their trademark. Government has given the opportunity for individuals. They can also file. They need a certain code, and the agent can also file. Now, who you might be wondering that who is the agent? See, filing IPR if any individual from the other field, we are from the legal background field, from any other field. Suppose I have done my engineering, but still I want to work in IPR. So what I could do? So government has provided certain training and exam process where you can appear even after you, if you have a different fields, even then you can also appear and get the code. Then you'll get the agent code for that, and you can do. So now as an attorney we will talk about it. So who could be our clients? If suppose I want to file IPR, like I want to file trademark, तो अपने clients कौन हो सकते हैं? Well, the clients would be individuals, companies, partnership firms, trust and societies. ये सारे अपने clients हो सकते हैं. Fine. So how it work? I mean, for the civil matters, we know we have to go court and it's a lengthy process, we can file. But here in this, we have an online platform available with us. So suppose if the client come to us, ma'am, I have running my business already. It's been 5 years since I am running like Banana Foods Limited, and I want to register this trademark and logo, whatever it is. So what we will do? First, we will see the logo, we will see the trademark word, and there is a platform which is provided by government, that is a nice classification. So in this nice classification, what the government has done, they have basically divided the certain goods and services in class. Suppose I my client is uh, my client is handling more about in the motor vehicle, so we need to search about the motor vehicle services. So the class will be, suppose it is class 12. So it is very important while filing the trademark application. It will help later, and how I will tell you how it works. Then what we have to do, what are the requirements? Suppose now the client come to us and I have to file. So what are the requirements? So how we are going to prepare ourselves? So for attorney, you need a code first. For that also, IP India website, there is a certain process where you will attach your Bar Council India registration form, and they will verify you, and then thereafter they will provide you attorney code, and that is a very very crucial code for you in order to get work done in IPR. So thereafter, you need a DSC, digital signature certificate, because the whole work is going to done via online only. So for that, you need a DSC. So it's better to get it done. And then what you will do? Now the client is not by himself do filing the application. You, being the attorney, are going to file the application. So here the you need a power of attorney. Your client will give you the power of attorney, and these are the things which you need to keep ready with you, along with their trademark, other information, their logo, their symbols, and all that. So how it works now? Now we will go to the application website like IP India. There you will get a form TMA. Now, where we have to provide the clear representation of the trademark, including logos and designs, and we have to put our class, in which class it is falling, which I have discussed bit earlier, and then a user declaration, that suppose whatever client my stating these and in giving other evidences, that's all correct. It's a user declaration, and these all things are required. So now moving further, I hope this much. I hope you guys understood, because I am more practically. I'm more discussing about the practical filing and procedure, because it will beneficial to you. Theoretical part is always in the book, because I never been taught in the colleges. So hope you guys getting it. So now I would discuss about the prior right. Suppose my what happens in this, if client wants to start my business, आज मुझे बिजनेस करना है, आई हैव मेड माई ट्रेडमार्क एंड लोगो, आई विल गो टू दी माई अटॉर्नी एंड से कि मैम आज मुझे स्टार्ट करना है, प्लीज गेट इट रजिस्टर, तब भी मैं कर सकती हूँ. बट suppose if my client has already been started business long back 5 years ago, then also I can apply for the registration. It doesn't mean that even if you are filing for fresh business, that only you can file. So let me talk about the prior rights. So what is prior rights? Suppose I am doing a business. It's been 5 years since I have done my business. I have created a very reputed goodwill. I have made my brand for my particular product. Now, after 6 years, I realized that I should get its registration. But I have already found the objection notice. Like somebody else have already filed the logo which I am using. So here I can take the opposition in that particular reply. See, I am using this. trademark long back, and I have I have created this goodwill and I have spent a lot of money making this brand. So in this way, you get a right. It doesn't mean that if you have registered your trademark, then only you will get the remedy. It doesn't have. It's not like that, because a trademark is not mandatory register. It's optional. So if the client comes to you, it's better to advise that it is better to advise to get it registered for more benefits. So what happens now? I have filed the application form. Now what's the next stage? So now I have filed. The next stage is examination. I have submitted my application to the registry. Now registrar is the whole person. You can say he takes a position of judge. So he examined the application. He will check whether the legal compliance meeting the requirements or not. So in between, if the registrar found that is falling under a grounds of refusal, we have section 9 and section 11 in trademark. That's our absolute grounds for refusal, which comes under section 9, and there are certain other relative grounds of refusal. So let me give one example. What are absolute ground of refusal? Suppose my brand is I have created a brand named Apple, and I am selling Apple only. So this is not a similar our IPR, our registrar never will grant the thing which is already in existence in nature, by nature, because the shape of apple is already being in the nature, and you are selling the apple, no dissimilarity. If suppose my brand name is Apple and I am selling the electronics item, then it is okay. So hope you'll get the point. Now then if we move to next, we can face the opposition. Now how opposition will come to us? I have filed the application. If the registrar thinks there is a no grounds for refusal, he will go forward. Now opposition, what is opposition? After the trademark is published in the trademark journal, so any interested party can file a opposition within a 4 month. This is a, I guess, a very long time. Within a 4 month, if it comes in my knowledge that somebody has already this is my brand and some other people is using my brand, we can file a opposition. See, this is my brand, you are not allowed to it. It's like that. And now the registrar will hear the both the parties and will research on it, whether we should provide it or not, whether they are doing business or they just have done the registration and all that. These will things will be checked by the registrar, and thereafter, if suppose no opposition is filed or no opposition is decided in favor of applicant, the trademark can be granted, right? Then what will happen? Then the publication will happen, and we can get the grant of license, and the lifeline of this trademark license is 10 year, and thereafter you can renewal it after 10 year. You can renewal it, but there is also one timeline. I think I'm not getting it's 1 month or something. If you get delayed, there are certain fines, I mean not fine, but late fees. But it's better to get it renewal within a time span. So now what challenges we are facing right now in India? So there are certain challenges, like awareness is a one challenge, that we are not aware. The startups are coming, they are not well equipped with the legal technicalities. What is the brand, or how I am creating a goodwill? So these are the challenges. So but the government is taking initiative. They are organizing certain workshop, and they between among the entrepreneurs, and they are providing certain information about the IPRC. These are all things. So and this is the one challenge, but this challenge is, I believe that it is getting less right now. And the second challenge is enforcement. Still our enforcement is a bit slow, because once we file the trademark application, it takes a very long time. Like it takes about 1 year to get it registered. after meddling with all the stages. And then the other thing is cost. Its cost is bit high. It is costly. Filing IPR is costly. So apart from this, I would like to discuss some more things about it. It will definitely help you in taking the clients. Uh, so let me talk about some jurisdiction also, because sometimes we won't get this jurisdiction. So jurisdiction in case of IPR dispute in India. So we have civil courts. So most IPR disputes, including related to patents, trademark, generally it addressed in the civil courts. And thereafter, if any party is not okay with the order, they can go to the High Court as well over the appeals, right? And they basically handles the cases concerning the validity of the trademark and patents. For example, Delhi High Court is known for adjudicating many significant IPR cases. And one recent case I would like to discuss, there is a Burger King case which is held recently in Pune. So let me brief about it. That brand is already been established in 90s here in Pune. At that time, the owner of that never visited the USA, never been in much active communication with the USA. Like they might, the owner, they never been known that this Burger King is already prevalent in the USA. That was the fact. And then when when the Burger King itself came in India and started doing a business, they found that in Pune they are doing the business. So this district court, this case went to district court, and district court gave the matter in favor of Pune Burger King. But is now again it's been challenged to the Mumbai High Court. Now the decision is left. So I would tell the what was their defense, like Pune Burger King's defense. They were saying their grounds were, see, we were not known long back when when established the our Burger King business. It was already prevalent in the USA. This was the main ground, because at that time there were, like today we have a live call came to me. I'm really sorry. So, what is our next jurisdiction? Our government of India has specialized some IP code also. Like some state may establish specialized IP tribunals or court handle IPR related matters. Now we have other court also. We have commercial court also, which has established in Commercial Court Act 2015, which entertain commercial dispute basically, and including those involving trademarks, patents, and can be heard in commercial courts. And thereafter we have mediation and arbitration also, that platform. So apart from this, I will give some general knowledge about it, like um, yes. So if the client comes to you and he has business not in India but in UK also, then he comes to you and say, ma'am, I want to get my trademark registered in India as well as in UK. So do you know that how you are going to apply IPR in your trademark in UK? Well, we have a platform, like in online way, we can simultaneously file the application in India and as well as in UK or in other nations wherever your client want to work. Suppose my client is dealing with the textile industry and his business not in only India but in different nations also. Then you have also options. You will tell your client, see, we can also file in India, and there are separate fees, and that is a whole other thing. We can file in other nations also. So that platform is also available to us. So better when clients come to you, you can say these things. Um, then So now this is it. Okay, let me tell one thing more. we might be hearing that IT industry is working on IPR very much. How now? We are wondering how they are working. So let me tell you, giving one example, like how they are dealing in IPR. They are earning a lakhs and lakhs from IPR field, though it is our field, but how they are earning? Let me tell you. What this IT company does, suppose IBM has developed one software, and that software is helpful in banking, in the transaction of banking, right? And none of place, there are no such technology has been developed yet. So what the bank will do to ease their business? The bank will go to the IBM company, sir, please give me your license. So do you think they will give a free license to you? No, they will grant you license, and for that they charge a huge fees. So what, who does work for them? We we lawyers do work for them. We grant a patent licensing. You might have heard the varieties of licensing. So I would suggest that you must all do some research over it, over the licensing work. We have a good scope over it. So that is all from my side. And now I am ready to take questions. Hope I would have justified my topic, because we have given very less time. And in that time, I tried to cover up all the practical aspects. Okay, yes, I'm ready